Good evening, everyone. Happy New Year, if it's not too late to say that. And thank you all for joining the Garden Court Community Care team on what, let's face it, is a very gloomy and grim Wednesday evening. Thank you for joining us. My name is Gráinne Mellon. I'm a barrister in the Public and Community Care law teams here in Garden Court, and I'm chairing this event this evening. We are, of course, presenting a review of case law and legal developments in community care in the last 12 months. And we have three brilliant speakers this evening from our community care team, and they will, between them, be addressing developments in legislation, guidance, policy and case law across adult and children's social care. We have, speaking first, Bethan Harris, who is one of our practitioners in community care, housing and court of protection. She is going to be speaking mainly about adult social care, looking at COVID legislation, guidance and policy, Care Act, case law, Care Act Easements. Of course, one of the big themes from the year, care home visits during COVID-19, and also some of the COVID-19 case law. Next will be Tim Baldwin, who also has a practice in housing, community care, court of protection and civil liberties work. He too is going to focus mainly on adult social care, and he's chosen 6 areas to speak about: the inherent jurisdiction, no recourse to public funds, destitution, healthcare, and unsurprisingly, once again, looking at some discrete elements in relation to the COVID regulations and in particular challenges to those. And last but very much not least is Nick Bano, who is one of our, in our housing and community care teams. He is going to review some of the recent case law under the Children Act, in particular looking at destitution, retrospective Section 1720 challenges, and an interesting new case on adult siblings. So I hope you'll agree we have a lot to cover. It's obviously been a busy year, and I think busy is possibly the most positive spin we can put on it. But thank you for joining us. And we would really like to hear from you during this seminar. So please do share any comments that you have in the chat function. And in particular, if you have any questions, we're really keen to, of course, answer those if we can. I'm going to try to gather them up and ask them at the end of the 3 presentations, just to make sure that we get through everything. And please use the Q&A box to ask your questions rather than the chat function if possible. So you should all see at the bottom of your screen, the very far right, a Q&A box. Please use that to ask any questions that you have. We do have some resources which you'll see shortly during the presentations. We will circulate those to all registered attendees in the coming days, so you will of course get a copy of them. And just also to mention that the webinar is being recorded, and to let you know about that, we may be sharing it on our website. And so if you speak, which we're not anticipating anyone other than the speakers doing, that will be something which may well be shared. Please, if you're having any difficulties, technical or otherwise, refer to the instructions which Amy has just put up in the chat window, and we will try to help. So thank you for bearing with us as we go through that housekeeping. And without further ado, I'll turn to Bethan Harris, who is our first speaker on adult social care.
Sorry, I'm nearly there. Oh. Right. Thank you for bearing with me. Thank you, Gráinne, for that introduction. I'm going to start by taking you through a chronological list of some legislation, guidance and policy during the course of the last 12 months, starting from March, starting with, unsurprisingly, a COVID-related set of guidance from the government concerning the ethical framework for adult social care, issued in March. aimed to guide planning and decision making in response to COVID-19, of course, of which there has been a great deal. And also in March, we had the coming into force of the Coronavirus Act, and that includes, of course, Schedule 12, which concerns the Care Act Easements, which I'll refer to a bit more later on. Then in June, jumping to June, a different topic, the ordinary residence rules in relation to the Mental Health Act, Section 117, and the government, the Secretary of State, issued a determination which contained a change of approach in relation to the situation where a person is owed a Section 117 duty and has been discharged into a different local authority area, and then is detained once again. And the issue that arises is which public bodies owe the Section 117 duty following the second detention and discharge. And the status quo, as reflected in the Care and Support statutory guidance, has been to date that the duty switches to the second set of public bodies, to the new area, but the Secretary of State has changed the view on that, and that has given rise to a judicial review brought by Worcestershire Council, and that has been heard just before Christmas, and judgment is awaited. Then at the next bullet point, I've highlighted the post-Brexit immigration scheme and the concerns within the social sector, indeed condemnation, according to the headline that I've cited, from the social care sector because of the impact on care worker recruitment. Then in September, the policy paper on adult social care, the Winter Plan, and also in September, the Joint Committee on Human Rights report on the government's response to COVID and the human rights implications, considering the issues that we are very familiar with, the main issues that have been of great concern during the last 10 months of lack of PPE for healthcare workers, blanket applications of do not attempt resuscitation notices, and changes in adult social care and children's social care, and of course the excess deaths in care homes during the pandemic. And then in December, the government's response to that report. In December, also what is the current visiting care homes guidance. I'll refer to that again a little bit later on. And then at the end of last month, the advice on priority groups for vaccination, who is going to be vaccinated in what order, and the government's plan that 13 million people will have had the opportunity of vaccination at least by mid next month. The current guidance that applies in relation to restrictions is, of course, the national lockdown stay-at-home guidance, and that comes hand in hand with the current restrictions under the 6th of January 2021 Health Protection Coronavirus Restrictions England All Tiers regulations, which puts the whole of England into Tier 4, and the restrictions and the exceptions to them are in Schedule 3A. We have the white paper now published on mental health reform, the deferral of the implementation of the liberty protection safeguards, and finally, I've noted the ongoing deferral of a green paper on the reform of social care, which has been outstanding for quite some time. The next part of my talk is going to concern developments in case law under the Care Act 2014. I'm going to highlight some cases which deal with principles, not necessarily raising new principles, but dealing with them in a way which is useful for practitioners to look at and assist with really kind of illuminating how the Care Act works. The first case is the case of Antoniak against Westminster City Council. And the principle emerging from this is that assessments under Section 9 of the Care Act should include all needs, regardless of whether they are currently being met. And this case is perhaps an example of how complicated Care Act assessments can sometimes seem in terms of trying to piece together how the decision-making process has proceeded and how the results that has ensued has been got to. In this case, the person concerned had various disabilities arising from a road accident and mental illness, was living in a temporary hostel, and so some of his needs were being met, and he was assessed under the Care Act at that time, and the outcome of that assessment was the local authority stating that he didn't need anything from the local authority because his needs were being met currently, and if he moved into independent accommodation, then he could be advised by a physiotherapist or an occupational therapist as to how to do things for himself. So that was the local authority's decision that he didn't have any eligible needs, and that was challenged, and it was found that there had been a failure to discharge the duties under Section 9 and Section 13 of the Care Act. Section 9 is the assessment duty. Section 13, as you know, is the duty to make a determination as to whether a person has eligible needs in accordance with the eligibility regulations. And the main point that comes out of this judgment is the finding that when needs are assessed, in a needs assessment, those are needs that are arising from the individual's own identity and characteristics, whether or not at the time of the assessment they are being met. That's not an entirely new principle in the case law surrounding the Care Act and commentary surrounding it, but it's, I think, quite a useful formulation in order to keep the eye on the ball as to what exactly needs to be assessed. Other points arising from this judgment, which I think are perhaps useful for practitioners, are the highlighting of the need for a stage-by-stage decision-making process, assessment of needs, followed by an eligibility decision, and only after that, the decision on meeting those needs. That straightforward structure can sometimes get lost. 3, I've highlighted the way the local authority put its case. It relied, at least in part, on Section 9(6) of the Care Act, which concerns consideration of whether matters other than care and support would contribute to the outcome that the adult wishes to achieve in day-to-day life. But it was held that that provision was not one that could be used in order to essentially sidestep the basic structured process of carrying out the assessment focused on the person's needs. So it's a useful case in highlighting really the sort of basic components of a Care Act assessment. Moving on to the case of Raja and Hussein against the London Borough of Redbridge in June of this year, this case highlights a number of useful points for practitioners. The claimants were 2 brothers who had significant disabilities. They were looked after in part by their mother, who provided for their nighttime needs. But when she was no longer fit to meet those needs, she asked the local authority to provide nighttime services. The local authority agreed to reassess the nighttime needs, and she asked for services to be put in pending that reassessment. And the case decided, the outcome of the case was that a mandatory order was made requiring the provision of nighttime care after the local authority had refused to provide it on an interim basis pending the reassessment of needs. So the points arising from this judgment, which are useful, are first of all that it confirms that the local authority has the power to provide services pending a reassessment in the same way as it does pending an assessment of needs under Section 19, so regardless of the fact that there is already a care and support plan in existence. It identifies that where there is a dispute about the provision of such interim services pending reassessment or assessment, what the court is looking at is it the sole justifiable response to make that provision? In this case, it was. There was evidence indicating that the 2 brothers did need to be looked after at night, and the mother was unable to do so. This case also usefully sets out the principles and procedure for reducing expert evidence in judicial review, and it's also endorsed by the judge as an appropriate use of the procedure of rolling judicial review being a challenge to an ongoing failure, and sets out the principles of when a rolling judicial review approach in the pleadings and the adducing of evidence is appropriate, and when it's not appropriate. So that's quite an important point in terms of for practitioners when considering how to formulate their claims, which comes up quite a bit, as we know, in community care. The next case is the case of Idolo against Bromley, and this deals with the interplay between social care and housing duties, and the tension that there is around this area of where care and support needs need to be met by the provision of housing or rehousing, not of a type which is a care home or supported living type, but more of a kind of ordinary type accommodation, although it may be with adaptations. And there is certainly a tension in this area. This is where Section 23 of the Care Act comes into play, and there doesn't seem to be much judicial comment on Section 23. This case, I think, goes some way to illuminating how the courts might regard Section 23, but perhaps doesn't tell us still everything about what is the precise scope of Section 23. So the facts of this case were that the claimant, Mr. Idolo, had lost the use of his legs. He lived in a flat with his family, and it couldn't accommodate a wheelchair, so he was stuck in one room for a long time. The local authorities' response from social services in terms of rehousing, because obviously the care package could only be implemented up to a point in his existing accommodation, was that he needed to apply to the housing register. All in all, it took 18 months for him to be rehoused, and during that time, he was just living in one room. And he brought a claim alleging breach of the Care Act and of also Article 8. So Section 23, you see at the foot of the slide, says a local authority may not meet needs under Sections 18 to 20, i.e. that's the duty to meet eligible needs, by doing anything which it or another local authority is required to do under the Housing Act 1996. So this case directly raised what happens when a person who needs rehousing to meet their care and support needs faces a long wait via the council housing register. And what was argued, unsurprisingly on behalf of the claimant, was that because the housing register did not provide a solution, certainly did not provide a solution for a long time, then that it was a situation where the Care Act duty should be engaged in relation to accommodation. But the court's response to this was that this was a case where the Housing Act duties were primarily engaged, which meant that the priority scheme under that act was applicable. And so Section 23 kicked in and prevented the claimant's argument from succeeding. Primarily engaged were sections 166A3 of the Act, that's the duty to formulate the housing allocation scheme in order to give priority to people who had welfare need, including disability needs, and also the homelessness duty, neither of which would kick in, of course, to provide a very good solution at all, although ultimately a solution in this particular case. And the court here repeating what has been said by the Court of Appeal about that claims for damages for maladministration type Article 8 claims for delays in meeting statutory duties should be brought by complaint, an ombudsman's complaint, rather than in the courts. Moving on to the final one of my review of Care Act case law, I move to the case of SH against Norfolk Council, which concerns the use of the Human Rights Act and Article 14 discrimination claim to challenge the local authorities' charging scheme. The local authorities entitled to charge for services under the Care Act, and SH is a person who suffers from Down syndrome and a severe learning disability and physical disabilities, reliant on ESA and PIP daily living component and mobility component. And she is not a person who would expect to have an earning capacity because of her severe disabilities. The charging policy to be introduced would increase her charge quite significantly. And the result was that the PIP daily living component would be taken into account in the means test, but she, unlike others, would not benefit from the disregard of earnings, whereas others would. And the claim under Article 14 succeeded, and the components of that, just very briefly, were that being severely disabled counted as an other status under Article 14, the status being ascertainable by reference to social security criteria, and that there were two analogous, there were two groups of people in analogous situations. They were, on the one hand, those who had severe disabilities and high care needs, which were significant barriers to work, who did not fare well under the new policy, and those who were not severely disabled and who were able to work, who would come out better under the policy. And this distinction in the third bullet point was able to meet the high threshold of being manifestly without reasonable foundation, and therefore was unjustified discrimination. The outcome was in fact unintended and perverse, and could have been avoided by setting up the charging system in a different way. And it's also interesting to notice, I've highlighted in the final bullet point, that the care and support statutory guidance, which the local authority must act under according to Section 78 of the Care Act, unless there's good reason not to, was very relevant in the reasoning of the court, as it dealt directly with the kind of approach which a local authority should take to charging. So moving on now from case law to the Care Act easements. Well, I know that we are by now familiar with the Care Act easements, which were introduced by the Coronavirus Act in March. They obviously modify the local authority's powers and duties in England under the Care Act, and it also in relation to Wales under the Wales and Social Services and Wellbeing Wales Act. The Care Act easements are in Schedule 12, Part 1 in relation to England, and the effect is essentially to suspend the main duties under the Care Act where a local authority decides to opt into them. And the bottom line duty that replaces the duty to meet eligible needs is a duty to meet those needs where it's necessary to meet them for the purpose of avoiding a breach of the adult or the carer's convention rights. The legislation has to be read with the guidance. The guidance sets out a threshold set of criteria of which the local authority must be satisfied, and also a decision-making process it must follow before it makes a decision to implement the easements. And it must notify its decision to various bodies. And if any local authority does implement the easements, this is to be published on the CQC's website. The address is given in the guidance, and on looking at it recently, there was still, it remained the case, as it has done for some time, that there were no local authorities currently operating the easements. Unless that's changed very recently, that would remain the case for now, at least. Most of these provisions will expire automatically after 2 years, and they're subject to a 6-monthly parliamentary review, the last of which was on the 30th of September. So 8 local authorities have used the easements to date, and as I say, no local authority is currently operating them as far as I'm aware. in terms of any litigation surrounding the easements, the one piece of potential litigation that I'm aware of is the threatened judicial review against Derbyshire County Council in respect of its decision to operate the easements on grounds that there was no evidence to show that the threshold for operating them had been satisfied and the decision to do so had not been taken in accordance with the guidance. The proceedings were not issued in the end because of some concessions that were made. So moving on from the easements, I now move to care homes and COVID. Obviously, this has been one of the areas of very pressing concern, has been the issue of visits to people of residents in care homes, and so much so that at the end of last year, Mr. Justice Hayden, Vice President of the Court of Protection, wrote open letters, as he put it, to try to address a great deal of confusion that had been amongst various professionals as to what the regulations actually required. And he wanted to impress the fact that contact was permitted and that having visitors was critical for supporting health and well-being of residents, and this could be facilitated by things such as screens, visiting pods and window visits. And he then emphasised again the approach that should be taken and the need to strive to find ways of enabling people to have contact with their loved ones who were in residential care. In the case of Davis in Wigan, this was the case of right at the end of last year, of Mrs. D, who was a stroke victim, and her contact with her husband had been typically of so many, largely by only smartphone for many months. And what Mr. Justice Hayden does here is he makes explicit what is the underlying framework for decision making in this area, which is that the needs of the individual do sometimes need to be displaced by the greater obligation to protect the wider public, but this does not absolve the care home or the state from making an effort to reconcile the interests of both. So that's obviously got a sort of underlying Human Rights Act analysis to it, most obviously Article 8. The scope of contact should be evaluated on an individual basis, not generic, so not a blanket rule. And there should be, in this case, further investigation of the options for Mrs. Davis. So moving to what's the current guidance on care homes, we have to look to the national lockdown stay-at-home guidance. Visits can take place, but with the necessary precautions. And also the December guidance requires, as reflecting the views of Mr. Justice Hayden, or consistent with them, individual needs and individual risk assessment is what is recommended as appropriate. Obviously, it's a very difficult context, and what happens on the ground obviously varies from care home to care home, as we know. Then my next point is to flag up that where we have to look now, of course, in order to find out what the restrictions are, is the Schedule 3A of the 2020 regulations. And there are separate provisions for exceptions in relation to people visiting care homes, and also what's known as deathbed visits, visits to people who are in a situation where they're dying. Those are dealt with separately. And there's separate guidance for supported living, which I think also includes extra care housing. In relation to the government's handling of the pandemic more generally, there is a judicial review afoot being brought by Dr. Cathy Gráinne, which has been given permission to proceed with a hearing which is expected in spring, arising out of the death of her father in April of this year, and concerning various aspects of the handling of the pandemic in relation to care homes. And very briefly, I will mention three further cases, two relating to children in relation to COVID. Firstly, a case which was successful as a challenge in November of this year, a challenge to the reduction in safeguards in children's social care in response to COVID, introducing temporary amendments to various statutory instruments, which impacted on the amount of scrutiny in relation to adoption processes and fostering and visits and social work input in relation to looked after children, which the court regarded as having a significant impact on children in care. And those regulations were successfully challenged for the failure of the Secretary of State to have consulted the bodies representing children in care and the Children's Commissioner. A challenge which wasn't successful was the case of Shaw against Secretary of State for Education in August. This was a judicial review brought in respect of 2 disabled children concerning the relaxation of time limits for completing and preparing EHC assessments and plans, and also the issue of statutory notices under the Coronavirus Act, which replaced duties to secure provision under EHC plans with a reasonable endeavours duty. So again, a watering down. And that wasn't successful at first instance, and permission to appeal was not granted on the basis that it was considered by the court to be academic, although in fact the Secretary of State doesn't still have power to issue such notices. So it was only academic in terms of the individuals concerned. So moving to my final slide, this is a very recent case on the 11th of January, and it concerns one of the exceptions to the restrictions on movement and gatherings, all under Schedule 3A of the Act. One of those exceptions is that a person can leave home if it's reasonably necessary for P, that's the person concerned, to leave or be outside their home to provide care or assistance to a vulnerable person or to a person who has a disability. And what this case raises is the scope of that exception, where a person is being looked after, not in a care home, but in ordinary accommodation, and family members go to the accommodation in order to provide care, or to visit and provide care for that person. That was the scenario in relation to an earlier formulation of the coronavirus restrictions regulations, but remaining relevant for the current version, in the case of NG and Hertfordshire County Council. And what the court held there was that the scope of that exception should not be read as meaning that the care was essential care, that parents who were visiting their son who lived in a flat with paid support were covered by that exception when they visited, and when visiting provided care for him, even though, as the welfare deputy in that case argued, their care could be replaced by an extension of the paid for care package. It wasn't necessary for their care to be thought of as indispensable and not capable of being replaced by paid care in order for them to bring themselves within the exception. So that was a broad rather than narrow interpretation of the scope of that exception in accordance with Article 8. That's everything. Thank you very much.
Thank you very much, Bethan. That was remarkable, and I'm sure everyone will agree that was an extremely comprehensive and helpful summary, which no doubt we'll all be able to draw on in the months ahead when we're preparing our own casework. I think the NG case is really important for those advising families and indeed local authorities at the minute, a really helpful clarification on that essential issue of contact. But also the Raza and Hussein case, thank you for reminding me of it, because it's really helpful, particularly on when reassessments are taking so long, not only because if somebody has a particularly complex need, but also in light of the COVID delays, it's a really helpful reminder of the power to provide services and also for local authorities to properly grapple with evidence presented and provide appropriate reasons. So thank you very, very much. Please do, if you have any comments or questions, please feel free to join in and to either leave a comment or a question in one of the boxes below. But for now, we're going to move on and we're going to hear from Tim Baldwin.
Thank you, Gráinne, and great to have this introduction from Bethan. I'm trying to focus in this part of the seminar on some cases of interest in adult social care that have occurred over the past year or so, and whether there are potentially other themes that are identified within those cases that could inform how community care develops over the next couple of years. And what I've done is pick about 6 cases that deal with these various points, that identify. Sorry, something's happened to. There we go. There are 6 points, and the cases identify something that's going on within the inherent jurisdiction and that's use, a case dealing with a no recourse to public funds and how that might be challenged or develop in the future, and whether destitution is to become more of a common issue or a common test that you will see within the context of local authorities making decisions in respect of provision of care and support, and also in respect of healthcare and persons from abroad. And then at the end, looking at 2 cases that one deals with a challenge to the COVID regulations, and secondly, looking at when enforcement action was taken to take a step under the COVID pandemic, and whether these indicate any themes or approaches that are emerging. The inherent jurisdiction and vulnerable adults is something that is still presently active within aspects of community care, even though you have the development of the Court of Protection. And it is interesting to look at this case of Marsa versus Birmingham Community Healthcare Foundation Trust of October of this year, because this appeal concerned a decision in respect to an out-of-hours application under the inherent jurisdiction of the High Court, where the order is made, and that order was made to deprive a person of their liberty by moving them from home into hospital. And the facts of the case was that the appellant had muscular dystrophy and he'd been living independently for some while, and he'd undergone some deterioration where he was placed on a ventilator and fed via a tube. But he retained capacity to make decisions, but he required 24-hour care, and that was provided by the NHS Trust at home. His family complained about some of the carers that he was receiving care from, and some of them were removed from the team. And what happened is that on one weekend, the NHS Trust were unable to provide carers over the weekend, and on the Friday before the weekend, looked to make an application to the Court of Protection, to the High Court, on an out-of-hours application, saying that the complaint arose out of the family members of the claimant having some form of undue influence over him. And what the application was to remove him from his home to hospital, with the judge making the order sought. And on appeal, the appellant said that his Article 5 rights had been breached. The Court of Appeal allowed the appeal to the extent that it was undoubtedly wrong, and set aside the order. And the court held that the judge had failed to adopt the correct approach. And the approach, the failures of the judge are outlined in these 5 points here as to how the judge failed to do this properly. And the court also held it was impossible to tell if the judge had considered the jurisdiction under which he was acting, and also being clear that judges, when being asked to address these things, had to be satisfied that that jurisdiction is satisfied, and also that the trust itself in making the application had not even considered the issue of jurisdiction. Namely, you're looking at something under the inherent jurisdiction where an adult has capacity to make decisions. It's not someone who is lacking mental capacity to make their own decisions. And the court then found that even assuming there was a jurisdiction to make the interim order in an emergency situation, the judge had to be satisfied on the evidence that there was reason to believe the factual situation was made out. And the court indicated there's no indication on the order the judge had applied that test, or on what basis they were satisfied that that test was made out. But what they also found, that even if the test had been applied, that there was manifestly insufficient evidence to meet it. And the court actually concluded there'd been a breach of the appellant's Article 6 rights and a flagrant denial of justice. And there was one of the things that came out of this was lessons to be learned. And this list here sets out a set of directions which the president of the family court is being asked to consider. But one of the things that does come from this is that it appears that in delivery of care for particularly vulnerable persons, that the inherent jurisdiction is still considered as a vital tool. And, even though you've got the development and expansion of the Court of Protection, and one of the issues that the Court of Appeal didn't really definitively resolve in this case is whether the inherent jurisdiction can be used to deprive an adult of their liberty. Because remember, the person was deprived of their liberty, even though they had capacity to make decisions about their own care and residence issues. And the only thing that's of note is that Lord Justice Baker posed the question was whether it could be used, was provided the provisions of Article 5 are met. And it suggests that it's clear that it cannot be properly used unless there's evidence commensurate with urgency and that person is of unsound mind within Article 5(1)(e) of the Convention. But then where are we looking at the inherent jurisdiction with the Court of Protection? And it did identify that when using the inherent jurisdiction, there had to be great care and a thorough review of the evidence and issues before the court. And it will be of interest to see what guidance, if any, issued by the President of the Family Court, whether they address this deprivation of liberty issue under the inherent jurisdiction, given existing case law of AB in Hertfordshire, and particularly in the context of when people are detained in hospital and then discharged and then placed in a placement whereby their liberty is deprived. Quickly moving on to this case, and this deals with an issue of the no recourse to public funds problem. And I'm going to call it a problem because if you attended the seminar before Christmas that was done with the team, you'll see the difficulty that this can provide. And this is a claim where the child sought judicial review of a defendant's imposition on their mother's grant of a leave to remain a condition that she was have no recourse to public funds. The claimant was a British national and was born in 2011. His mother was from Gráinne. And the claimant's mother was granted a leave to remain as the claimant's parents under what's called the 10-route settlement scheme in 2013. And this is a scheme, if you're not familiar with this, whereby you apply for a particular route to get some form of settled status in the end after a particular period of time. And what this type of grant of leave led to leave to remain of sequential grants of 30 months at a time. And routinely such grants are made subject to condition by the defendant that the applicant had no recourse to public funds, i.e. welfare benefits, social housing, and so on and so forth. And the effect of the condition was that the applicant was ineligible for almost all welfare benefits, including to maintain the basic welfare of their children. And the claimant's mother worked as a carer, but the imposition of the no recourse provision had led to her and the claimant to endure periods of destitution. And in the last application, she provided evidence to the defendant that she and her child would be destitute if this condition was imposed. Nevertheless, the then defendant imposed the condition. And the claim challenged the imposition of the condition in this case, and also the legal regime under which the condition was imposed. And what I've outlined there is the legal basis and the then instruction to caseworkers as to how that was imposed. The claim was allowed on a previous hearing, but the remaining challenge challenged the legality of the regime under where the claimant argued that the regime itself failed to ensure that imposing the no recourse condition would not result in inhuman treatment contrary to Article 3 of the Convention. And you can see what the court held in terms of what the correct approach would be. And that was to ask whether the regime, when read as a whole, gave rise to a real risk of unlawful outcomes in a significant or more than minimal number of cases. And that was the outcome. And there was a condition in terms of whether this amendment could be regulated, remedied by amendments to the instruction to caseworkers. So they succeeded on all grounds. The obligation is not to impose a condition which would lead to destitution in the 11th Whaler sense. And the court also made mandatory order that it should publish the instruction to caseworkers within 7 days. Also, the defendant agreed to pay the claimant a sum of £3,000 in compensation. So we're looking at the ability of people to access care and support, public support, whereby a refusal of that would lead to destitution. The other area where destitution has been an issue of late is in respect of the provision of accommodation and support under Section 4 of the Immigration and Asylum Act 1999. And that piece of legislation was specifically designed to protect vulnerable people from destitution and to protect them against inhuman and degrading treatment caused by homelessness. This is designed primarily to protect people whose asylum claims have failed and they're unable to return to their home country, or they still have some issue that needs to be resolved before the courts in this country. And the court, in this case, the DMA case, identified there were wholesale failures by the Secretary of State to monitor the implementation and contracts awarded to private companies, which is found to have led to unreasonable and unlawful delays in provision of accommodation and support pursuant to Section 4 of the Immigration and Asylum Act, and thus breached Article 3. What had happened is that the Secretary of State had accepted a duty was owed to various individuals, a duty to provide them with accommodation and support under this piece of statute. However, in any event, they were subject to long periods of homelessness and destitution, and also they're vulnerable due to various physical and mental health conditions, risk of harm arising as a result. And this has been particularly common and there have been a whole series of delays, particularly aggravated by COVID over the past year, if you've had any dealings with this type of litigation. And the full judgment was very highly critical of the ongoing failure of the government to monitor and their lack of engagement with the failure. And it's likely to lead to sort of further examination, because it's a key in the judgment that where there was a failure of the judgment identifies as a failure of a private contractual arrangement, which led to the breach of Article 3, and the Secretary of State's failure to know how the contract was being performed was itself unlawful. And it's one thing to just look at this case in isolation, but one has to also consider whether this is not unique. There's a massive growth in service provision by the private sector of the government, and it's unlikely that this failure in terms of monitoring and ensuring that these private contractual arrangements are unique. So it opens the doors in some way to investigation of systematic failures to provide services in other areas of care provision. I'm running a little short on time, but this case of RMP concerns payment for NHS treatment and foreign nationals. And this appeal concerned a judicial review challenge to the lawfulness of the National Health Service charges for overseas visitors amendment regulation 2017. The defendant was held to be under no duty to carry out a public consultation on the proposed extensions of the terms of the 2015 regulations relating to advance payments by overseas visitors and record keeping. And in this case, the appellant was an overseas visitor who appealed the dismissal of his claim for judicial review in respect of these provisions. And the 2015 regulations permitted the NHS to recover charges for services provided to overseas visitors. And in December 2015, the government launched a consultation on the proposed extension to the 2015 regulations. But in 2017, regulations were enacted with amendments requiring overseas visitors to make advanced treatment for payments for advanced treatment and for keeping of records of chargeable persons. The appellant sought a judicial review of these regulations, claiming that these new requirements were intrinsically linked to the subject of the 2015 consultation and significantly affected the impact of the proposals. In other words, it was a failure to, the allegation was a failure to consult in respect of these new provisions. And the court concluded that the defendant had not acted unlawfully in carrying out the consultation exercise in 2015 without including the new proposals, and that the appellant did not have a legitimate expectation arising out of past practice of public consultation that there would be a consultation on these amendments. What I've done on this slide, which you'll get, is to outline in about 4 points as to how the court arrived at its decision. The case is likely to serve in some ways as a template for future circumstances in respect of issues of consultation and changes into such charging regulations in respect of persons from abroad. So it's worthwhile looking at this case in some detail to see how the judge concluded that, and if further cases on charging come up, particularly in relation to healthcare, it's worth referring back to that and seeing how the court made that distinction in respect of the obligation to consult. We've heard a lot about COVID regulations already, and the question that always comes to my mind is that every day we seem bombarded by changes to COVID regulations, and I believe there's been about 64 changes to the regulations overall since March of last year, and we see a huge amount of commentary and posturing and notions of what various COVID regulations might mean, and also what the guidance might mean, and we don't see a huge amount of actual what you might call frontline challenge to those regulations and how to go about it, and what, if anything, has been the impact of any challenge that might be relevant to social care and how care is provided. I thought that this recent case might be illustrative of how the courts approach the challenge to regulations and whether challenges can or cannot be effective. And a recent case addressed the issue of what is self-isolation under the coronavirus restrictions, self-isolation, England's regulations 2020. And we hear a lot of people being required to self-isolate or isolate or quarantine themselves or shield themselves. But we don't really have a clear vision as to what that actually means. And in the case of Francis, which I refer to here, it says the court held that the concept of self-isolation under the health protection regulations was not the same as isolation or quarantine, which in the context of the defendant's power to legislate involved acts of clinicians. So, and this is to do with the power of clinicians under the Public Health Act, Control of Diseases Act 1984, and it's section 45C, which involved acts by clinicians. And what the claimant sought in this judicial review was to quash the health protection, coronavirus restrictions, self-isolation regulations on the basis that the defendant had no power to impose them. And what I've extracted here, because we're running out of time, is the what the regulations were designed to deal with, and it was which required anyone notified of a positive test to self-isolate, and the regulations were made under the 1984 Act, and it was inserted by the Health and Social Care Act of 2008 with the purpose of providing flexible and wider powers to deal with pandemics. And what it did was looked at the particular section 45, section 45C, G, D, and various subsections of that, and namely about potentially infected individuals being required to submit to medical examination, to be removed or detained in hospital or other suitable establishment, or that they be kept in isolation or quarantine. So really the power of clinicians to effectively get hold of somebody who's infected and take them out of the community and quarantine them. And in interpreting the meaning of a particular section, that's 45G2D, of the 1984 Act, the court rejected the premise of the claimant's argument that self-isolation was the same as isolation or quarantine. So what you have is the court having to address this issue as to a provision whereby somebody could be forcibly isolated. Moving on to the final case I'm going to talk about, because I've just got 1 minute left on my time. This is a case where somebody was forcibly removed from hospital as a result of an injunction. This is the case of University College London Hospitals Trust versus MB, involving a patient who refused to leave the ward to go home to a package of care in the community. Originally, the hospital issued a claim seeking possession of the bedroom from the defendant, but then the claim was reconstituted as an injunction claim when the judge, Mr. Justice Chamberlain, drew the parties' attention to the fact that there was a stay on possession claims under Part 55 for a period of days. And MB's position was that she wished to leave hospital, but only once her concerns about the care package and the accommodation to which she was to be discharged had been addressed. And it was submitted on her behalf that unless these concerns were addressed to her satisfaction, she would, as a result of a mental condition and disabilities, suffer extreme distress, which might lead to self-harm or suicide. And it was contended that the decision to require her to leave hospital involved a breach of Article 3, Article 8 and Article 14 rights, and also contrary to Section 29 of the Equality Act. And the judge accepted that her behaviours were caused or connected to her mental health difficulties, which were disabilities within the meaning of the Equality Act and for the purposes of Article 14 of the Convention. But the judge considered that the various private law rights of the hospital balanced against the public law defences and human rights and a discrimination claim. And the judge, in the end, concluded there was no sustainable defence of the claim for an injunction, and in respect of the judicial review, in respect of any judicial review which might have been brought, which actually wasn't, that there was no sustainability of that, and if one had been brought before him, he would have dismissed it and refused permission as totally without merit. One of the things that it did identify, although very fact-specific, it does give guidance on the approach to various issues under COVID-19, especially in respect of discharge of persons from hospital, and how, if people resist that, how, firstly, how to legally enforce COVID-19 discharge requirements, the procedural elements and requirements to resolve those matters, what human rights arguments were to be considered and how they were to be applied and considered, and how decisions of hospitals to require patients to leave hospital who are medically fit and who don't require inpatient care but have challenged their care packages will be approached and scrutinised by the court, and what types of evidence is required by other hospitals in respect of mounting such a claim in the future. So that's it for me, and I'm going to stop there because I'm a little bit over time to hand over to Nick.
Thank you very much, Tim. That was really interesting to see the points that you've pulled out from those cases. And in particular, it's interesting to think how the pandemic may have affected or infused some of that case. So I'm thinking in particular the no recourse to public funds case, which obviously was a huge success for the claimants and the intervener, and a sort of a recognition by the judiciary that migrant families with leave to remain needed to access a welfare safety net when they were at imminent risk of destitution, not when they actually were destitute. So I think it's useful to remember that there were some positive and progressive decisions last year. Thank you very much. And Nick, we're now going to hear from you on updates in children?
Okay. Does that work? Do you hearing me?
Yes,
Great. Okay. Thank you very much. I'm looking at the Children Act cases of 2020, and you'll be pleased to know that there aren't very many of them. But what I'm proposing to do is look at it in two parts. The first is to look at one of this year's cases, a case called AA, because it's interesting to look at where AA leaves us in terms of destitution, no recourse to public funds, and in particular what I and other practitioners have taken to calling the culture of disbelief, when social workers and local authorities focus on inconsistencies or gaps in the evidence and don't believe that families are destitute. And then after that, we'll come on to look at the 2 or 3 interesting Children Act cases that we've seen this year. So starting then with a case called AA. And it was a very common scenario, the sort of thing that practitioners see all the time, where a family with no recourse to public funds that included children had applied to a local authority as destitute, having relied on informal community support for a number of months before their approach. And having been messed around a bit by the local authority, who were chasing them for information and sending them away, eventually interim relief was granted by the High Court. And shortly after that, the council produced a Section 17 assessment. And what the assessment said in summary was, we don't believe you. We think there are discrepancies. We think there are inconsistencies in your case. So we are not going to treat you as destitute. And where this comes from, although there were cases before Owen Lambeth, is this statement of the law from Deputy High Court Judge Helen Mountfield QC in Owen Lambeth, where she held that local authorities can and indeed rationally should look quite carefully at the background where a no recourse to public funds family has been in the community without the need for support from the local authority and has suddenly turned up and said, we are destitute, we have nothing, we have nowhere to go. And it's a 2016 case. It feels like we've been litigating it forever, but in fact, it's only 5 years old. And what's happened since 2016 is that local authorities, and particularly hard-pressed local authorities in larger cities, have taken this point and run with it. And what we tend to see in the case law is social workers being incredibly astute as to what they perceive to be inconsistencies or gaps in information, and coming to the view that they disbelieve the applicant. And what's interesting about Owen Lambeth and what we learned from AA and Southwark is the sheer body of case law. We know from our practice that most of these cases don't go anywhere near a final hearing. They settle in one form or another. But since 2016, we now have 9 full judgments of the High Court in the Owen Lambeth line. And it's interesting to look at them because they're not a code of guidance as such, but together they form quite a useful body of case law and give us something approaching a set of rules or principles in these cases where there is disbelief. And perhaps more importantly than that, they give us a clue as to how the courts are likely to approach them. Because it sometimes feels like there can be an underconfidence when there's a credibility issue, that lawyers and litigants are worried that in credibility cases, the court won't interfere with the social worker's findings. And of course, it's quite right to say that credibility cases are difficult and can be very, very difficult. But I think the law gives us more cause for confidence than perhaps it's traditional to see. So what I'm going to do, if it's all right, is to look at each of these 9 cases briefly, because they're good to have in our toolbox when these credibility issues arise. So the first case is S and Haringey, and it was very shortly after the Lambeth case. And the Deputy High Court judge allowed the claim because it had been wrong, the judge held, for the council to draw adverse conclusions about credibility before the matters of concern had been put to the applicant for an explanation. It's a familiar public law principle, but it was applied successfully in this case. The claimant successfully argued that it was procedurally unfair that the applicant hadn't had a chance to deal with these causes of concern. And it's a useful decision that sets the boundary for Owen Lambeth and the cases in that line. Then the OK case was handed down the following year. And similarly, the High Court held that Barking and Dagenham had been overzealous in their application of the Owen Lambeth case. What had happened in OK was that the local authority had become a bit obsessed with company documents. The applicant had been self-employed, and the council said, we're not satisfied with the extent to which you've disclosed these company documents. We think you're being dishonest. That was wrong, that was unlawful, and the High Court held that the family and their representatives had in fact gone to inordinate lengths. And the judge made this interesting comment that the council had become entrenched. It was so committed to reaching a conclusion that the family was being dishonest that really it had turned away from the evidence that pointed towards their credibility, and it had disregarded it. And again, that's a very helpful case because it defines the boundary of that Owen Lambeth principle. And it's a case where the High Court went relatively far in criticising a local authority for taking this forensic approach to an application from a destitute person. The next case is CO and Lewisham, and that was another success for the claimant. It didn't start well for the claimant. The Home Office had already found that the family was not destitute, and an earlier judicial review of the local authority had failed, but the family won. Because since the previous judicial review, the applicant had provided new evidence. And again, the council hadn't really engaged with the new evidence, and as is now a familiar point, hadn't put their concerns about the evidence before they drew those adverse inferences. So those are themes that are becoming familiar now looking at the cases, failing to put matters and closing one's eyes to evidence that's favourable to the applicant. We start to get a sense that the High Court does spot it and it doesn't like it. AC and Lambeth, on the other hand, didn't go so well for the claimant. Like the Lewisham case, there had been a previous determination by the Home Office that the family was not destitute. And one of the difficulties was that AC hadn't really done anything to challenge that when the Home Office had promulgated it. And Lambeth then uncovered genuine deficiencies with the applicant's address history. It turned out that she hadn't stayed where she said she had, and she had one address which she hadn't disclosed. And when Lambeth raised these problems, the claimant didn't really do very much about them for about 3 months. And then the sort of thing that as practitioners we all wake up in a cold sweat about, the mother's witness statement was contradicted by independent evidence from one of the people with whom she said she'd stayed. So the claim didn't succeed on that point about failing to put adverse credibility findings. My colleague Gráinne, who we heard from earlier, did end up succeeding in this claim on a different ground. And the reason I focus on the case is that Mrs. Justice Chima Grubb's summary of the law on credibility is very, very good, although that point didn't succeed. So it's a case that's well worth looking at. Stewart is the next case, and it was another unsuccessful challenge. There was a reluctance, the court found, to provide full disclosure, and at least one sort of palpable or provable example of untruthfulness by the applicant. and at least one item of material non-disclosure by the applicant. So the court, looking at the evidence, found as a fact that the claimant had declined to disclose information. And in fact, the claimant actually accepted that there'd been reluctance to disclose information. Their explanation was they wanted the permission of the people whose details they were about to give. But it's easy to see that there was a very strong basis for an adverse credibility finding there, when even the claimant himself said, yes, fair enough, I have been a bit reluctant to give you the whole truth. The Bexley case then was another success for the destitute family. Again, a failure to put relevant matters. The court arrived at the same result, but a slightly different route. The court said that when you haven't put matters of concern, they are in fact irrelevant matters that you're not entitled to rely on. So rather than the procedural fairness point, it's a slightly different public law ground. But again, it's the court reminding us of the importance of putting matters of concern. And also what's interesting about Bexley is that the credibility concerns simply paled into insignificance on the facts, because the family was homeless, there was no dispute, and didn't have the right to rent. So credibility concerns didn't matter. And then the SN case failed. Again, there was a very, very firm basis for the court and the local authority to conclude that the family had credibility issues. There was independent evidence saying that the family had never stayed at a particular address, and the family's own evidence was internally inconsistent. And that brings us to this year's case of AA, which was another success for the claimant. And what's interesting about AA is that you can see the spectres of those previous cases haunting the Section 17 assessment. For example, the council had tried quite hard to get the excluder to say that the family had never lived there, because that had worked in SN and AC, and that was what they wanted to go for. And they tried their hardest to say that the family had been unforthcoming, because that's what had worked in O and Stewart and cases like that. So we know that local authorities and social workers take these cases very, very seriously and learn from them. And we all ought to do the same. But it didn't work in AA, and that was for two reasons. The first was that Southwark hadn't dealt with what the solicitors had said. Every time Southwark raised its adverse inferences, the solicitors were very careful to challenge what the council had said and to provide an explanation for any matters of concern. And the social worker simply hadn't dealt with the new information. So every time the council's case on credibility was undermined, the council turned away from that aspect. And the High Court said that that was unlawful. They hadn't properly dealt with the material that helped the claimant, that went in her favour. And the second reason was deficient inquiries. As I'd said, they tried quite hard to get evidence disproving that the family had stayed with this particular friend. Really, they tried to put words in this person's mouth. And when that failed, and when the solicitors said, no, you've got this wrong, we can provide evidence, the social worker sort of abandoned the point. And what struck the High Court was that if this point mattered so much to the social worker at an earlier stage, so that we're required to get to the bottom of it, they couldn't just walk away when it wasn't working for them anymore. So the assessment was quashed, even though it had become academic in between the case being heard and judgment being handed down, because the no recourse had been lifted. So conclusions we can draw from these culture of disbelief cases. Claims will fail when there are lies. We've seen the weaker cases, AC, Stewart and SN, where it can be corroborated that the applicant has been untruthful. And those are the cases where councils are bound to succeed. Failure to put matters seems to be the most common hurdle in these cases. The courts have repeatedly said that the lawful thing to do is to put the matter before you reach an adverse credibility finding, so before it makes its way into a Section 17 assessment. It shouldn't be a game of ping pong where the Section 17 assessment appears with all these credibility concerns that the applicant has never seen before, even if that leads to a new reassessment. Really, it's got to be done before the decision maker reaches an adverse credibility view. When we zoom out a bit, like the Bexley case, credibility isn't always important. This was a point that we tried to run in AA as well, because the family was in so much debt that it was pointless to look at their day-to-day spending. They were in £9,000 of debt, but it's not a point the judge really picked up on in that case, although they had in earlier cases. But sometimes we can avoid arguments about credibility by zooming out and saying, look, obviously homeless, obviously destitute, credibility doesn't matter. Challenging concerns, that's really why cases like AA have succeeded and others have failed, where credibility concerns have been full-throatedly challenged and well evidenced by representatives. That's really, really important. And the High Court has noted and pointed out that councils can become bloody-minded, and the court doesn't like it. And the final point is that social workers will be found out. And I think so that we're quite lucky in AA, because one of the points a social worker had made when they were trying to disprove that the family stayed at a particular address was that she'd spotted some children's underpants on a washing line when she got around to have a look. And therefore there must be credibility concerns. Obviously an absurd point, but the court didn't really get into it. But if it had, it would have been embarrassing for Southwark to pin their case on the existence of a pair of children's underpants. So that's the culture of disbelief. Moving on to look at some of the other cases that have come up this year. AB and Ealing is one of them. In fact, it just nudges into 2019, but it was December, so I think we're okay. This was a young lady, a child, who'd had a very, very difficult upbringing. Her parents had various problems, as did she, and it culminated in her leaving home at 17 and a half. And at that point, a Section 17 assessment was done, but it didn't actually conclude as to whether she was a child in need, and it didn't decide as to whether she ought to be accommodated under Section 20. She was staying with initially with a boyfriend and then at a refuge. And what later happened was there was a retrospective challenge to that failure after she turned 18, because the council refused to treat her as a former relevant child. And her case was, if you'd done a lawful Section 17 assessment, you would have had to assess my accommodation. You would have had to accommodate me. I would have been a former relevant child. And there's a principle, GE Eritrea, that was relied on, that the council could use its discretion to treat her as a former relevant child under Section 23C to make up for its previous unlawful conduct, i.e. the defective Section 17 assessment. And what the case boiled down to, because Ealing conceded that she had been a child in need, what it boiled down to was whether the council had correctly applied the Section 20 criteria in the assessment. And I have to say it was quite bravely argued by Ealing, because nowhere in the assessment did the social worker actually consider the Section 20 question, which was whether the accommodation was reasonable. Ealing's case was that when you look at all the documents, and it was a very lengthy Section 17 report, you could sort of understand what they were getting at. But the High Court said, while there was an awful lot of detail, there was very little analysis. They took a sort of quality, not quantity approach. They said, reading the decision as a whole, Section 20 hadn't been complied with. The assessment didn't lawfully consider the proper test, which was suitability. And therefore, the earlier decision not to accommodate under Section 20 had been irrational. And this is good, because we often see in all sorts of public law challenges, public bodies saying, this is a very detailed decision, therefore it must be lawful. That approach didn't pass muster with the High Court judge in this case. So well done to those who brought it. And there's an interesting point at the end that Ealing had relied on a letter in their evidence that post-dated the assessment by some time, and the court, looking at the old jurisprudence, said it doesn't really help us with what the decision actually said. So that's a nice point if local authorities try to shore up their case later on. The next case then is a case called OA and Bexley, and this is a case about support for adult siblings. And it's a desperately sad and difficult situation, because it's a case in which there was a child in need and his older brother and their mother, and all three had no recourse to public funds. No problem about the child being in need, no problem about meeting the mother's needs. But the difficulty was the council took the view that it didn't have the power to grant any funding for the adult brother, although the adult brother was very important in the child's life, and therefore awarded payment at their single parent, one child rate. So you had a factual scenario where a child was going hungry because the food wouldn't go round, even though the council accepted that the child was in need and supporting him because of the needs of the adult brother. And the key point in this case was whether Section 17 permitted or actually prevented Bexley from funding a no recourse to public funds adult. And obviously the council said that Section 17 doesn't allow them to do that. The no recourse to public funds restrictions are there for a reason, and we can't use Section 17 to get around it. And the claimant's case was that Section 17 is quite permissive. As long as something's done with a view to safeguarding, you don't need the payment or the support to be necessary. The claim was dismissed. The claimant went some way to succeeding, and the judge held that family should be widely construed. It's not limited to parents. It's not limited to those with parental responsibility. So notionally, there's no problem with funding older siblings and other family members who are adults. But there is a necessity requirement. The court looked carefully at the words of Section 17 and said that the services must always be appropriate to the needs of the child. And it took that word needs as meaning it must be necessary in order to support the child to make these payments. And going one step further, there's a limit, a hard limit on what support can be provided. It may only prevent a breach of convention rights. So what we learn is if we want to achieve support for elder siblings, and from the local authority's perspective, if they want the power to provide support for older siblings, we'll have to make the case that the sibling relationship is more than just very important. It's more than just supportive, that the well-being of the older sibling is actually necessary to promote the interests of the child as well. And then finally, there's a secure accommodation case, which I won't look at in much detail. It's an incredibly sad case about a very, very troubled child who didn't have capacity to consent to deprivation of liberty, was at suicide risk, but simply there was no suitable, available regulated placement in the whole country. And the High Court described it as a brutal reality, but said the state of affairs is the court has no choice but to allow, or rather order, the child to stay in an unregulated placement because of the lack of availability. That was first decided on the 26th of October. Days later, the Children's Commissioner produced a short briefing note noting that the government was really doing very little about this, was barely even monitoring it. And there's a sort of cadre of children in this very, very unsatisfactory position. And then within days of that report, the case came back before the judge, who noted the contents of the Children's Commissioner's report and noted that the government isn't really doing anything about this. But again, because there was no unregulated regulated placement, there was still no choice for the court but to order the child to remain there. And then looking at what's coming up, and this may come up in questions, what are we likely to see in 2021? These are four possibilities, possibly more Section 17 approaches as the everyone in provisions start to come to an end. This is the emergency homelessness provision. We may see more children having to rely on Section 17 for accommodation, possibly an increase in destitution cases, given likely job losses, particularly for those with no recourse to public funds, possibly more reliance on children's social care for EU nationals without settled status who will no longer be entitled to Part 7 homelessness assistance once we have fully left the EU. And finally, and this is the only one I haven't put a question mark by, is huge pressure on social services departments. We hope they won't resort to the culture of disbelief, given the line of cases that we've gone through, but it's certainly a risk. And that's all from me. I think there's some time left for questions.
Thank you very much, Nick. And that's actually a very helpful place to end, with your four observations from a children's social care point of view about what may be ahead in 2021. We don't have very much time left, but I wanted to see, Bethan and Tim, whether you had anything you would add to Nick's list in terms of what we can expect in the months ahead and future themes or possible issues that may come to the fore this year.
Bethan, you're muted. Bethan, you're muted.
For you to go first, Tim?
No, you are muted, so you can go first.
Okay. Okay, well, I suppose what immediately comes to mind, and I'm sure Tim will comment on COVID type cases, but is we've still got the liberty protection safeguards, which have been mentioned. They're not planned to come in the forthcoming year, but there will be consultation on regulations and code of practice. So that will be quite an important process for that move from DOLS to liberty protection safeguards. And I think other than that, I would comment on, I suppose it's sort of general kind of climate that we're in is, bound to be lots happening in social care, a situation where there's, so much scope for getting a perspective on how social care works and copes, which ultimately is going to feed into reform, which is going to have to come. So we will know so much more about our system when finally we do have a process of reforming the social care system, which has been found to be wanting in so many ways already.
Thank you, Beth and Tim. Any thoughts?
I think in addition to what Nick identified in terms of use of section 1720 and the culture of disbelief, there will probably be greater use of, or attempts to use, local authority powers, for example, under the Localism Act and the Human Rights Act in respect of issues around destitution and provision of accommodation and support, particularly when individuals may have particular care needs. So there probably a greater pressure on local authorities in general to deal with issues of destitution in the next year or so, not just out of unemployment and issues like that, but generally the impending change and changes in the immigration law and how that is approached, and especially in respect of EU nationals after about June. That's one area that's going to be of vital importance locally, really people understanding what all the local authority powers are and how they can be used. There's going to be a radical change, I think, in the way that mental health law operates over the next couple of years. We're expecting a white paper arising out of a report, and how it's envisaged that may change, particularly when there is an over-detention of persons from minorities, especially from people with Afro-Caribbean backgrounds. That is something that is actually quite a scandal that's not been really addressed. And generally, I think what you're going to see is there's supposed to be a green paper on the future of social care that's been floating around for years. I just think that the government will sort of do an accounting thing at the end of next year and really revisit what levels of social care can be provided by the state. I anticipate that there'll be a redrawing of lines and a greater restriction.
Thank you, Tim. And I'm conscious we were due to finish at 6:30. So I think that probably has to conclude our seminar this evening. Thank you all very much for joining us, 200 of you at one point, although dwindling now as people go hopefully to make some dinner or have some time to themselves. Thank you for joining us. You'll receive the materials from Amy and our marketing team over the next few days. And thank you as always for your ongoing interest. And we look forward to hopefully seeing you in person at some point soon later this year. Thank you all and good evening.